Answer.com. Now, from the Signature Bank Studios. This is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here, and Tulsi Gabbard declassifying more information relating to the Russiagate hoax in furtherance of a long overdue reckoning, politically, legally. Email between former DNI James Clap-on, Clap-off, James Clapper, and NSA Director Mike Rogers about the January 2017 revised intel assessment as to Russian interference in the 2016 election, ordered by Obama, you'll recall. Rogers returning from a trip overseas, communicating he's updated on the current status of our efforts to produce a joint product related to Russian attribution and intent for the DNC, DCCC hacks. I know this activity is on a fast track, he wrote in December of 2016. However, I wanted to reach out to you directly to let you know some of the concerns I have with what I'm hearing from my folks. They were clear in saying that at the staff level, folks have been forward-leaning and trying to ensure that we have an opportunity to weigh in. But I'm concerned that, given the expedited nature of this activity, my folks aren't fully comfortable saying that we've had enough time to review all of the intelligence to be absolutely confident in their assessments. Why the rush? In addition, if NSA is intended to be co-author on this project, I personally expect to see even the most sensitive evidence related to the conclusion. That was Mike Rogers to Clapper. Well, Clapper responds by essentially coming over the top and saying, you got to get on board here. Clapper writing back, it's essential that we, CIA, NSA, FBI, ODNI, be on the same page and are supportive of the report. In the highest tradition of, that's our story and we're sticking to it. And sticking to it they have, boy, that's parenthetical. He went on, did Clapper, we will facilitate as much mutual transparency as possible as we complete the report, but more time is not negotiable. We may have to compromise on our normal modalities. There's a phrase that'll go down in infamy. Compromise on our normal modalities since we must do this on such a compressed schedule. And here it is. This is one project that has to be a team sport. You say team sport, I say criminal conspiracy. For more on the top, well, but before we get to that, I should add, it is interesting whatever is happening with the grand jury that has been impaneled on this, because we've got now our second pronouncement from somebody sophisticated enough to know about controlling expectations. First, J.D. Vance over the weekend in his sit down with Maria Bartiromo expects indictments forthcoming. And then indictments forthcoming spectic Matt Taibbi, who has pretty good sources inside the Beltway, and along with Michael Schellenberger and a few other investigative reporters, pretty good sources, it seems, within the intel community. Matt Taibbi had this to say on Fredo Cuomo's program.
I think there are going to be indictments. I was very skeptical on that question even a couple of weeks ago, but I have heard repeatedly from these folks that they understand that this is not a hearts and minds contest and that they are not doing this for show, and that if they don't end up in a courtroom, that this will be a massive political failure for them. So I do think that there will be significant indictments. I just don't know what for. I mean, I think that's a very important question to ask right now. We know a grand jury has been convened, but they haven't really given us a strong indication about what crimes they might be investigating.
Well, let's talk about the what for with Rachel Paulose. She served as U.S. Attorney for the District of Minnesota from 2006 to 2008. She's written on the topic over at The Spectator. Rachel Paulose, thanks for joining us. Appreciate it.
Good morning. Thank you for having me, Dan.
So I don't know what. I think there are going to be indictments, but I don't know what for. Care to offer some possible what fors?
I'm concerned about the same issue, and so as a former prosecutor, I think the what for is the question. And as I wrote in my column, the what for, the answer to the what for that the DNI director gave was possibly treason. Treason is a very, very difficult crime to indict, and even more difficult to prove. In the history of the United States, the Justice Department has only convicted 12 people of treason, prosecuted only 40 cases. It's the only crime that's actually defined by the U.S. Constitution. And I think the difficult aspect here is that treason requires the Department of Justice to prove not only loyalty to an enemy, demonstrating an intent to betray, but also the provision of aid and comfort to that enemy. And so the challenge for the department in proving treason, at least, which was the specific crime mentioned by Director Gabbard, will be going beyond showing disloyalty to President Trump, but actually showing loyalty and provision of aid to some foreign government, perhaps Russia.
Well, I mean, okay, maybe not treason. What about seditious conspiracy? Like was charged against a couple of the J6 defendants.
That's a possibility, and I think that's a closer fit than treason. So seditious conspiracy requires, again, basically an attempt to take down the government of the United States or to oppose the authority of the government, generally by force. And so the question for sedition is going to be what was the forcible act under 18 U.S.C. 2384?
Well, right. I mean, but look, I mean, if you think that's what these agency heads and maybe others were engaged in was a fifth column action against the incoming and incumbent administration, then I don't know that physical force is the standard in terms of interpreting that statute. It's plotting to sideline the administration. I mean, just as the case here is, there may have been, and I'm not saying these charges were warranted, but if you want to make out the case against a couple of the J6 defendants that were charged with seditious conspiracy, they didn't necessarily engage in physical violence themselves, but the case was they organized, and the inevitable consequence of what they organized in terms of this attempt to overthrow or attempt to set aside the election results resulted in violence, and thus the additional charges beyond the seditious conspiracy. But the conspiracy alleged is the fifth column action, and I don't think it was legitimate in the case of J6 because I don't think it was a coup d'etat attempt. But here you have people at the highest levels of the most powerful agencies that, as the evidence continues to mount, seem to be engaged in something akin to that.
I think it's an interesting question. I think I'd have to look at the case law further, Dan, frankly, to see if there's been a case where sedition was charged and proven where someone in the conspiracy didn't use some sort of force, because that word repeatedly appears in the statute. And so that would be my concern with that. Again, I don't dispute that there was certainly an attempt to undermine the president and to make his to question his authority at every turn and make his tenure difficult, and to stop the lawful transfer of authority in some ways. But
yeah, I mean, you're accusing him of conspiring with Putin or being Putin's Manchurian candidate. You're trying to get him implicated in at least an impeachment, if not treason, and removed from office one way or the other. And to me, and I mean, I hear you and I agree with you. I haven't shepherdized this either, so I'm just sort of talking theoretically. But I mean, you're not talking about outside agitators, so or outside insurrectionists. You're talking about, let's say, the head of the FBI, the head of the Department of National Intelligence, the head of the CIA. Everything they do comes with the force of the federal government. Government is force. So everything they do has an implication of force.
It's an interesting argument, Dan. So I haven't heard that before, but the argument would be that because they're within the government, that they carry the imprimatur of force by virtue of the office that they hold. That's the argument that you're making.
Yeah. Mm-hmm. Mm-hmm. Yeah. I mean, it's just something to kick around. I'll let you barristers figure it out. I'm just So what got one more idea here too, and this is not novel. You probably heard Mike Davis from Article 3 Project and others suggesting this as well. Well, first, obviously, perjury. And then the question is, has the statute run on some of the pretty clear examples of perjuring oneself under oath? Was there a conspiracy to commit perjury such that you can maybe pull forward the actual examples of perjury, even if the statute has run, because there were other acts in furtherance of the conspiracy that told the statute? You know how that was. So that's one. That's one perjury, conspiracy to commit perjury, and then also 18 U.S. Code 241, conspiracy against rights, conspire to injure, oppress, threaten, or intimidate any person in free exercise or enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States. That's also been advanced. What do you think of perjury, conspiracy to commit perjury, conspiracy against rights?
I think those are both more tenable than some of the other charges that have been mentioned. The challenge, again, that you mentioned is the statute of limitations. Now, the statute of limitations on perjury, I believe, is 5 years. The statute of limitations on conspiracy against rights is, I have to look that up.
I think that's 5. I think it's 5 too.
It's also 5. Okay. Yeah. And so the Department of Justice is going to be in a battle against time on that. And again, the question will be, this evidence was already reviewed and considered by a really brilliant career attorney, John Durham. I don't think they get any better than John Durham, both in terms of technical ability as well as just character. And he had a really challenging time coming up with both indictments and convictions, suffered 2 acquittals, but did secure 1 guilty plea on essentially doctoring a document, essentially
right. Klein-Smith, right. Mm-hmm.
Exactly. As you well know. So it's difficult for me to imagine how going over the same ground again gets a different result the third time around.
But is it your sense that there may be information that DNI Gabbard and now Bondi and her strike force are obtaining that was not made available to John Durham?
I do not know the answer to that question.
Yeah.
And so I obviously have not seen what Mr. Durham saw. I don't know what Director Gabbard has seen. I think perhaps the greatest gift that Director Gabbard could give to the American people is to declassify as much of this information as possible, so that even if convictions aren't forthcoming because of technical issues like statute of limitations, the American people can see for themselves the truth about what really happened and who did what, for what motivation, and what sort of conspiracies did exist and what sort of bad intentions did lay behind all of these efforts to undermine the president even before he was elected. And so showing that information to the American people unredacted, undoctored, in the original words of the people who laid these plots, would be an enormous service. And if that's the best that can happen out of this, that is still a worthwhile endeavor.
Right. And what's your take on sort of this process of parceling out information that particularly Tulsi Gabbard has been going through and doing? It's a little bit at a time. And I understand there's a process to declassify and there's traps that you have to run. But I think it's also purposeful that they're doing it, and she is doing it a little bit at a time so that it's consumable. We can pour over it, like this email exchange between Clapper and Rogers, put it in the larger context of other things we know, and sort of continue to sort of bring people along as we have conversations about the latest information that becomes available and so forth. Because, the rule of law is the most important thing. And a grand jury proceedings have to be done in secret. I understand that, but public opinion. That we're talking about, things that implicate the future of our republic. So public opinion matters too. And I think it's actually quite shrewd, the approach that she's taken so far.
I agree with what you said, that the rule of law is the most important thing. The rule of law was not always observed in the years preceding President Trump, as we can well see from these documents that have been released now. And just because one side plays dirty does not mean that the other side needs to sink to that level. And so it is extremely important that Director Gabbard is releasing these documents in a deliberative and thoughtful way that follows the process. I have no doubt that she's also facing some internal pressure from bureaucrats or other people within her own agency who, for their own reasons, do not want to see documents released. But I think she's trying to be as transparent as possible within the limits of the law and following the appropriate procedures to release or declassify information. And as I say, that's an enormous benefit to the American people.
Rachel Paulose served as a U.S. attorney for the District of Minnesota from 2006 to 2008. You can check out her piece that we've been referencing at The Spectator, How to Jail the Russian Hoax Colluders. Rachel, thanks so much for joining us. Appreciate it.
Thank you, Dan. Have a great day.
You too. And she joined us on the Turnkey.pro answer line.
There's only one radio show in Chicago talking about today's biggest stories and telling you what they really mean. That show is this one, Chicago's Morning Answer on AM 560, The Answer.
Did you know that AM 560 Radio has a full-service digital marketing